How to compel a trustee to do their job. When dealing with a trustee who just won't do their job, compelling them via court order has been the traditional route for recourse. But even if you expect litigation to go in your favor, it's important to take the proper steps to ensure the trust itself comes out unscathed. Trustees are required to follow the direction of the trust to the letter, but that's commonly not how all trustees function in the real world. Hostility towards a beneficiary, a belief that the wording of the trust fails to reflect the true beliefs of the settlor, or the thought of utilizing the trust funds as a personal piggy bank or a new source of passive income can motivate a trustee to neglect or even defy the trust's terms, making legal intervention necessary. Your first step in these cases should be to contact a trust litigation attorney who can evaluate the trust to determine whether the trustee is holding up their end of the bargain. If not, they'll likely recommend sending a demand letter, seeking either an accounting of the trust, turn over relevant documents or other information, or that a particular action be taken by the trustee. If you're lucky, the threat of litigation will spur the trustee to act as they should. If the trustee remains resistant, non-compliant, your next motion is to file a petition with the court. The petitioning process can require a 60-day waiting period if it's being filed to compel the production of relevant information, including an accounting. It can even take longer. If a resolution can't be brokered by the end of whatever that period is, it'll be necessary to file a petition with the court asking them to order specific action on the trustee's part or potentially replace them entirely. In the event of other issues, for instance, if the trustee is threatening to breach their duties or steal funds, you can petition the court immediately. If the trustee's actions are severe enough to warrant immediate action, it may be prudent to file a petition as soon as possible to protect the trust and your interest in it, even if you continue to attempt to resolve whatever the issue is with the trustee informally while you're waiting to hear back from the court. If a resolution can't be brokered, for example, by the end of the 60-day period, it's going to be necessary to file a petition with the court, asking the court to make specific orders, forcing the trustee to do what they should do, or again, potentially even replace them. Unfortunately, legal action could threaten the value of the trust, even if the cause you're pursuing is entirely justified, because a trustee often will use trust funds to defend themselves in their administration of the trust. And depending on the court's local rules, there might not be a lot you can do to stop it, although you can always seek relief from the court and ask them to restrict the trustee from using trust assets in their defense. I've seen this happen a number of times over my many years of practice, as judges often won't take action to censure or replace a trustee before they've started using trust funds to defend themselves. While the court often and ultimately will order repayment of funds, in whole or in part, collecting on it can create another issue and another set of headaches for you to deal with. More recently, many courts have begun to implement rules to address this specific issue. For example, judges have begun issuing early orders prohibiting trustees from utilizing trust assets to bankroll litigation. Also, sometimes they set a specific cap on the amount of funds that are to be used toward their defense, or authorize an equal amount of trust funds to be used toward the other party's fees. These early creative solutions can serve to level the playing field between the trustee and the other litigants. While it's always worth making informal efforts to resolve matters and avoid litigation, a mistake commonly made by those in a dispute with a trustee is allow this inactive period to drag on too long. It's important to involve a trust litigation attorney as soon as possible, so they can help you document communications, ensure the rules are being followed, not just by the trustee, but by you as well, and pursue appropriate actions in court or otherwise as necessary. If you suspect a trustee is acting improperly, you should reach out to a qualified trust litigation attorney. At RMO, we protect people like you every day. Contact us today to see how we might be able to help.